Okay. Good morning again, good afternoon, good evening, everyone, and welcome to our webinar on International Court of Justice Advisory Opinion on Climate Change Obligations and its implications for investment policymaking. My name is Suzy Nikiema, and I'm Director of Investment Law and Policy Workstream at the International Institute for Sustainable Development, IISD, and I'm glad to welcome you to this webinar. As you might have heard, this summer, the International Court of Justice, ICJ, issued a landmark advisory opinion confirming states have a legal duty to take ambitious climate action. This ruling is likely to significantly impact the legal playing field for investment governance. For years, investment treaties have been used to challenge climate regulations, contributing to a regulatory chill. Will that change with the advisory opinion? Today, our expert panel will explore how this ICJ decision provides a powerful legal tool for states to defend their policies, shift the risk landscape for fossil fuel investors, and makes the need for investment treaty reform more urgent than ever. So it's my pleasure to introduce our three estimated panelists that have joined us for this exciting discussion that we will be conducting in two parts. In the first part of the webinar, the speaker will be Jennifer Banstad. Jennifer is a team leader of the Earth Negotiation Bulletin ENB at ISD. If you have not been a subscriber of ENB, please do so, and we'll be putting the link on the chat right now. She has been leading ENB coverage on the UN Framework Convention on Climate Change and the Intergovernmental Panel on Climate Change, among other multilateral processes, for several years. Her coverage of the ICJ advisory opinion process provides us with a unique perspective on the proceedings and the significance for international environmental law, global climate policy, and litigation. In the second part of the webinar, which focuses on investment law and policy, we are delighted to be joined by Mamadou Ebie, who is an Associate Professor of International Law at the Grotius Center for International Legal Studies at Leiden University. He is a practitioner of international law who has served as special assistant to the president of the International Court of Justice. Professor Ebie has also been part of litigation teams at the ICJ and the International Tribunal for the Law of the Sea, ITLOS, and has experience with investor-state disputes. And in the advisory opinion proceedings, he represented Burkina Faso. Professor Ebie will be joined by Catherine Armifar, who is a partner at Debevoise and Plimpton in New York. Mrs. Armifar is co-chair of the International Dispute Resolution and Public International Law groups at the firm. And she is a highly respected practitioner in international arbitration and public international law, representing states, corporations, and international organizations in a wide range of issues. She is the past president of the American Society of International Law, and in the advisory opinion proceedings, she represented the Commission on Small Island States on Climate Change and International Law, COSIS, as well as the government of Bangladesh. Jennifer, Mamadou, and Catherine, welcome, and thank you for joining us today. This discussion will be moderated by my two great colleagues, Elena Kozolapova and Joseph Ostrensky, both Senior Policy Advisor at ISD. I hope you enjoy the discussion today, and I now hand over the floor to Yelena for the first part of the webinar. Thank you very much.
Thank you so much, Suzy, and welcome everyone. A few housekeeping points before we begin. This session is being recorded, and the recording will be made available on the ISD event page after the session. Please submit your questions at any time using the Q&A box at the bottom of your screen. We will try to address as many of your questions as we can in the final segment. We will also share any resources or references mentioned via the chat. Finally, we have live interpretation in French and Spanish. If you want to switch to any one of those languages, please use the globe icon at the bottom of your Zoom interface. So with that out of the way, without further ado, I would like to turn to Jennifer. Can Jennifer's camera be switched on, please?
I have.
Oh, very good, very good. Hi, Jennifer. How are you?
Good. Thanks for having me.
Thank you for joining us. So 2025 will likely go down in history as the year when the ICJ finally weighed in on states' legal obligations with respect to climate change and clarified the consequences of their breach. But we first heard of the possibility of bringing a climate change case before the ICJ back in 2002 when Tuvalu considered bringing a claim against the United States and Australia. The idea of pursuing a contentious claim was later abandoned for a number of reasons. And then in 2011, Palau, with the support of more than 30 like-minded countries, led an attempt to have the General Assembly request an ICJ advisory opinion to clarify the legal responsibility of the largest emitters. Faced with pushback from a major economy, this initiative was also postponed. Now, Jennifer, could you briefly walk us through the process that led to the advisory opinion that we now have?
Yeah, sure. I mean, you outlined a lot of key turning points already. I think it gives a clear indication that this has been in the works for quite some time. And beyond the specific sort of attempts at bringing a case forward the court, it sort of inscribes itself in this broader trend towards increased numbers of climate litigation. And here I think it's quite timely. The UN Environment Programme, together with the Sabin Center, just published a report that takes stock of all these court cases and shows this increasing trend at the regional scale before national courts in various countries. But indeed, 2025 is this big milestone event, I'd say, not because just the process we had in The Hague, but also the Inter-American Human Rights Court. We have a new initiative launched in Africa similarly. But so going back to this process here, we had these sort of initial attempts to bring forward a case that, of course, creates a lot of geopolitical tensions, right? So it's been quite a challenge for proponents to rally enough support with other countries, especially to bring forward a resolution for the UN General Assembly as a whole to call for such an advisory opinion. And so I think it was quite useful that we had pioneers who attempted to do so. Tuvalu very early on emphasizing the importance of global treaties like the Kyoto Protocol and trying to pressure back then the US and Australia into responding, but also the mobilization of different kinds of stakeholders. This time it was successful also through student-led initiatives from Pacific Islands students, and the government of Vanuatu picked that initiative up and really spearheaded the development of what would become the UN resolution that called for the International Court of Justice's advisory opinion. You had different types of countries that quickly signaled support. You had CARICOM signal support, the Pacific Island Forum quickly signal support, but eventually we had 130 co-sponsors for that resolution. That's really a powerful signal, and the resolution was then adopted by consensus. And even more spectacular, you can see record-breaking numbers of countries and international organizations that had submitted written comments at the start of the whole procedure. We had comments on other countries and submitters' statements. And then we had loads and loads of countries being represented physically at the oral hearings in December 2024. We had a lot of countries speaking in front of the court for the first time. And that was really something quite powerful, also because it changed the style of the proceeding quite a lot. We had people from the front lines bear witness and bring testimonies, also through video materials and showcasing interviews, highlighting scientific data in front of the court. So that was something very noticeable about the process. And that served as a basis for the judge's reflections that drew on a large body of international law and the testimonies put forward in front of the court for them to prepare their advisory opinion, which was quickly released already, right? It's a bit more than 6 months after the hearing. That's impressive. Yeah. I think maybe highlighting the last step, now that we have the opinion, it's also the question of what will happen next. And right at the public sitting, Vanuatu already informed everyone of their intent to start preparing a General Assembly resolution that would respond and take up the advisory opinion. So I think that sort of brings us back to how will the UN General Assembly respond to the court's advice.
Thank you, Jennifer, for this background and for providing, a broader picture. This is great. Now, on to my next question. The ICJ advisory opinion has set a clear legal benchmark, removing ambiguities that may have existed around countries' obligations under international law with respect to climate change. Now, at the SDG Knowledge Hub that I lead, we've been unpacking the far-reaching implications of this ruling for countries' climate plans, for fossil fuel production, human rights, intergenerational equity proceedings in other courts, and many, many others. Could you perhaps highlight 3 or 4 findings that, in your opinion, Jennifer, are particularly salient and explain what they mean for states' climate action going forward?
Yeah, I think it's a really tricky thing to just pinpoint a few. I encourage everybody to read the sort of thematic takes on the advisory opinion that Elena just mentioned from different perspectives. The advisory opinion itself is really long. It's, around, I think, 140 pages long, and it's very detailed. And so it's clear that different stakeholders highlight different things that they see as really essential and bringing us a step forward. I work mainly on the international climate change negotiations. And so I think the first thing that I want to highlight is the specification with regards to the nationally determined contributions. So the NDCs that parties to the Paris Agreement are supposed to submit. The court clarified that this is not just a box-ticking exercise. Countries have to submit NDCs, but also the content of these NDCs is not entirely up to their discretion. It's not just you submit this document and then you've accomplished your duties. The court clarified different substantive expectations. And so key things are that these NDCs that are submitted every 5 years, they have to represent a progression over time. This is really key. This is the whole idea of the ratcheting up mechanism of the Paris Agreement. So with increasing capacity, new developments in technology, best available knowledge, countries are expected to present more ambitious plans. They are also supposed to take into account the results of the global stocktake. So this process under the Paris Agreement that assesses collective progress and implementation. And so that's a key thing because the first global stocktake issued specific calls that I'm sure we'll talk more during the event, specifically with regards to the transition away from fossil fuels and towards increasing renewable energy. So there's this clear expectations of what countries are supposed to put forward, and also a clear expectation that countries are to undertake best efforts to implement them. So they're not just a paper tiger. It's this balance, right, between not just putting forward something ambitious and then having no intention to deliver on it, right? I think that's really a key thing. A key element in that regard about assessing what is ambitious enough, what is best effort, is that the court emphasized it really depends on each party's, so each country's own capability and their level of development. And so the benchmark of what is, the most ambitious and best efforts depends on each country's situation. I think another powerful thing is that the court clarified that there is no evading of climate obligations. That's an argument that we heard quite a lot from high-emitting countries in the hearing. Countries do not only incur climate-related obligations under the UN Framework Convention on Climate Change or the Paris Agreement. They also have obligations related to other environmental agreements, human rights law, and customary international law. So even if you leave the climate treaties, you still have obligations. And a general one, but very powerful one, is that they are to prevent significant harm to the environment. And one thing that tends to be a bit glossed over sometimes because it's a bit more technical is the expectation to conduct environmental impact assessment for activities that may have an impact, a transboundary impact, which is here the case for activities related to climate change. I think a big thing there is also what do these assessments pertain? And there we see super important references by the court, specifically with regards to the production of fossil fuels. And I'm sure the panel later will discuss this in more detail. The responsibility for states to regulate the conduct of private actors, so businesses, for example, that are under the jurisdiction. That's really important with regards to fossil fuel exploration, the licensing, and taking account not just the emissions that happen during the production of fossil fuels, but really also the downstream effect. And that's quite a novum. So some highlights from my side.
Great. Thank you so much for these, Jennifer. And now I'd like to turn to my last question for you. Thanks to the advisory opinion, we now have legal clarity. But of course, there is an ongoing political process on climate change. We have now less than 2 weeks before the climate COP in Brazil. How do you think the advisory opinion will interact with the climate talks?
Yeah, that's a really tricky one. The thing is, the advisory opinion is what you make of it, right? It was widely acclaimed as a huge step forward in terms of climate justice. And we've heard people say, for example, that certain arguments cannot be done anymore in good faith about what is the state of climate-related obligations. That is true. But then how will it really impact the climate negotiations? They have their own way of operating. And we all know that the advisory opinion is non-binding, right? So it's a question of, on the one hand, political will to really incorporate those clarifications, but also the questions of, is anyone going to put forward a claim sort of responding to the clarifications of the court? And that's something that will happen outside of the climate negotiation processes. I think the biggest expectations that we had, and which was disappointed, I'm afraid to say, is related to these NDCs. The court clarified the expectations and said, this is not just a if you want, you can, and ticking box exercise. And it hasn't really changed anything. There was an original deadline for countries to submit those NDCs in February. Few did, a few more trickled in over the summer, some more in September with the UN General Assembly event on that. But we're going into the climate change negotiations and we are still missing a lot of those NDCs. And the ones that were submitted are not up to the task in terms of content, right? So that's one of the difficult things that you see. I think it takes people to take forward the advisory opinion. Otherwise, the impact will be rather limited. Another thing to highlight, perhaps, is that the advisory opinion gives a lot of fodder for people to reference, right? And that, of course, gives strength to arguments. So that's definitely one of the things that I'll be looking out for when I'll be covering the negotiations with the Earth Negotiations Bulletin, for references to the ICJs determination also when it comes to adaptation or to the provision of finance, for example, because there too we have specifications by the court that it's not just you provide finance at will or this is a charity. There are clear expectations with regards to international cooperation in the form of, for example, financial support. So it really depends. And I think a lot of island states are big candidates, right, to reference the ICJ in the negotiations. And then we'll see. I think a big thing to emphasize is that these countries that co-sponsored the resolution calling for this advisory opinion that in front of the court were not very progressive or provided a very let's say constructive arguments from a climate systems perspective, right? And so you need to differentiate between sort of on paper support and welcoming details and then countries' actual domestic actions and the way they engage in the negotiations. So I think it will be a test case. And just to highlight that the influence of this advisory opinion goes beyond just the climate negotiations. I've seen text being negotiated at the Biodiversity Convention right now, where there were debates, for example, about referencing the ICJ's advisory opinion. So it's creating waves if people try to, right? And so we'll see how far that goes. Thank you.
This is great to see how much traction the advisory opinion is getting. Thank you so much, Jennifer. This brings us to the end of the first segment of this webinar. And with this, I would like to hand it over to Joseph. Joseph, the floor is yours.
Thank you so much, Elena and Jennifer. So I would like to move now to that second part of the webinar to discuss the impact of the advisory opinion on policy making and turn to Catherine and Mamadou. And more specifically, we're interested in impacts on investment treaty reform and ISDS or investment treaty arbitration cases. How the advisory opinion strengthens the case for reforming treaty provisions of fourth-generation treaties, how the opinion may be used in arbitration to defend climate measures and counter arguments about investors' legitimate expectations in various sectors, for instance, the already mentioned fossil fuels. So I'll first turn to Mamadou. The advisory opinion clearly identifies, as Jennifer said, states' obligation to regulate the conduct of public and private operators within their jurisdictional control. So I would like to ask you, how do you see this finding potentially changing or influencing the way investment treaties are negotiated? And if so, which provisions do you think are likely to be the most affected ones? I think you're still on mute, Mamadou.
Okay, let's go. So thank you very much for having me. Your question raises really two important points in the advisory opinion, because the court had to deal with the acts and omissions of state in respect of climate change, and it did exactly that. It found that actually states, through their act, may engage their responsibility, and through their omissions and therefore their abstention, their failure to regulate, they may also engage their international responsibility. Now, let's think first about their acts. What can they do with respect to private actors, which may trigger their international responsibility? I will focus primarily on the fossil fuel industry, because I believe that they are the one we all have in the back of our minds. So the first one, through their acts, that the court clearly identifies is actually subsidies to production or consumption of fossil fuel. A state that is providing subsidies for the consumption or production of fossil fuel may engage its international responsibility in relation to its general duty to protect and preserve the climate system. The second point that the court mentions is that actually states may also engage their international responsibility with respect to by licensing the production of fossil fuel. So this is one important aspect that we have to keep in mind. And now when you come also to the failure to regulate, so state omission, that also can be a ground for international responsibility. And we all remember this famous statement of the court where it says that failure to regulate the production, exploration, consumption, please allow me to add transportation, stockage of fossil fuel, may actually also trigger state responsibility. Basically, what the court is saying is that states' engagement with fossil fuel in whether it is through their action or their omission, is now a risky business. Which means that when states are looking at their investment policies, they have to find ways to mitigate or to manage the risk that their engagement in activities relating to fossil fuel has now become. And that will raise two questions. What do we do with existing investment? Because there are a lot of vested investment that already exists in the fossil fuel industry, and any attempt for a state to terminate its subsidies or its licensing may trigger international responsibility with respect to their, based on their investment law obligation. And then you also have the question of future investment. Future investment, so investment that has not yet occurred, they will also have to think about it and how they take it into account in their investment treaty policy. So I think that the clauses based therefore on this view of both the nature of the conduct that is required from state and the nature of the investment that are protected, that may be affected by the measures that they will take to comply with their climate change obligation. I anticipate that actually the obligations that will be affected will probably be the prohibition against expropriation without compensation, definitely, including indirect expropriation, because the termination of subsidies or of licenses will give rise. We all remember the solar panel cases, so you can see where this will go. Of course, fair and equitable treatment has become now a big obligation where claimants try to put almost everything, and they would also question whether the state actions in compliance with climate change are in line with its fair and equitable obligations. Then you can also think about all these provision on regulatory measures. States have been trying to strengthen these clauses in their treaties, but you see that they are going about it in various ways. I anticipate that actually the new this climate change advisor opinion might give rise to a new generation of regulatory power clauses, which will be designed to safeguard actually the measures that they will adopt in order to support climate action. And finally, I think that they will need also to think about compensation. Because all these issues boil down at the end on compensation. Should climate action give rise to compensation, despite the fact that these obligations have been clarified, or in light of the fact that these obligations have been clarified by the International Court of Justice? So you see that the first two obligations will be backward looking, and the last two one will rather be forward looking in the sense that how do we ensure that the state keeps its regulatory space, and how does it manage the financial risk that its climate action measures may trigger. Yeah, thank you.
Thank you so much, Mamadou. So this is essentially, so you highlighted a couple of treaty provisions that are likely to be impacted, especially going forward: indirect expropriation, FET, you mentioned compensation and damages. Now, Catherine, currently and historically, a big chunk of the ISDS cases deals with investment in, for instance, the energy sector. Of course, we just discussed fossil fuels and also renewables that Mamadou mentioned. And the advisory opinion held that there is an erga omnes obligation to protect the climate change. So how do you think that this finding will affect the interpretation of the existing treaties rather than negotiation of new treaties, but essentially the arguments that states and other parties can bring and raise in investment treaty arbitration?
Thank you very much. And I just want to say what a pleasure and privilege it is to be with this group and talking about this today. So I think that, erga omnes obligations really gets into the weeds of international law that very few actually care about. So I'm going to focus on the actual practical implications of it and give you a sense of it. My bottom line answer is that it's quite significant. These particular findings of the court when it comes to erga omnes and erga omnes partes obligations have significant implications under international law, which I think also reverberates with the ISDS system and investment arbitration. So I focus on three aspects of this. The first is that investment tribunals' interpretation of BITs are far more likely to be influenced by the force and import of states' climate obligations. And that's because erga omnes and erga omnes partes obligations carry normative weight. As the ICJ explained in the landmark Barcelona traction case, they are owed to the international community as a whole because of the importance of the rights involved. And that is a higher order right, if you will. Comparable of prior examples of erga omnes obligations include prohibitions on the acts of aggression, genocide, slavery, racial discrimination, which all reflect, in the court's words, the principles and rules concerning the basic rights of the human person. So fundamental norms of the international system. And with respect to climate change, in this recent advisory opinion, the ICJ found very specifically that protection of the climate system and other parts of the environment from anthropogenic GHG emissions, and the obligation to prevent significant transboundary harm under customary international law under these particular treaties are at the level of erga omnes obligations. And so that particular finding means the import of those norms bear on the interpretation of other legal regimes. And this is where the investment arbitration regime comes in. And here, in very prescient opinion, Judge Werentry in 1997 in Hungary v. Slovakia actually talked about what it means for a bilateral structure of international dispute settlement, which is obviously between particular parties. How does it coincide with the emergence of community interests, these universal interests, and that how these universal interests warrant a different approach to interpreting states' rights and obligations in the context of what are effectively bilateral contentious cases, i.e. here, investment arbitration. And to quote him in his separate opinion, he said, international environmental law will need to proceed beyond weighing the rights and obligations of parties within a closed compartment of individual state self-interest unrelated to the global concerns of humanity as a whole. So that's the context in which now climate change obligations, protection of the climate system come up in the sense of normative force. And it includes not just their normative importance vis-a-vis other rights, but that there's a greater opportunity for horizontal enforcement of these obligations because state liabilities allows for all states to enforce these obligations rather than limiting it to a pool of particular claimants who are specifically injured or specifically affected states. So it really elevates those norms to a universal level. The second aspect of it is, and I'll be brief on this point because it's really a matter of interpretive principles, but the takeaway point is that the court's findings suggest that pursuant to Article 31.3c of the Vienna Convention on the Law of Treaties, climate-related obligations must be taken into account when interpreting investment treaties. And what that particular provision of the VCLT provides is that treaties shall be read alongside, quote, any relevant rules of international law applicable to the relations between the parties. And it's often referred to as an interpretive principle, systemic integration. So it's a very basic interpretive principle. The language of its scope is very much in debate as to how it applies in different contexts. But here, the court's conclusion that these climate obligations are owed erga omnes honestly settles the debate in the context of climate. And in the context of climate, these are not solely multilateral treaty obligations or bilateral obligations. They apply with equal force in relations with each other, with states with each other, because each state has a legal interest in the other state's compliance, irrespective of specific injury. So that is a very, very profound interpretive shift by virtue of the erga omnes finding. If you look at Judge Cleveland's separate opinion, she actually tips her hat to this, where she says, and I'll quote her, the interpretation of investment instruments must be informed by states' obligations in respect of climate change under international law, including the stringent due diligence standard to which states are bound in implementing such obligations. So in a nutshell, you have this interpretive framework that flows from the erga omnes. And then finally, I think we'll turn back to this, is that while it's not contingent specifically on the erga omnes finding, it's the path of defenses. And Mamadou, you referenced this as well, is what does it mean to comply with international investment obligations when states have these concurrent normative obligations to protect the climate system? And so you can see this coming into play as a potential full defense to liability for respondent state and investment cases on the basis of climate obligations that are owed erga omnes. And so we can talk about what that looks like. There's a very notorious case, a famous case of Philip Morris v. Uruguay, where an investor challenged Uruguay's legislation, which required tobacco products to include prominent health warnings. It had 80% of the package. And there, Uruguay defended it as a legitimate exercise of its police powers. The tribunal agreed. What was interesting about that case is the tribunal appreciated Uruguay's defense arose in the context of clear scientific findings, unimpeachable clear scientific findings, which we have here, and the fact that Uruguay had other international obligations around public health and safety that it was required to implement. So you can see that even though it's an older case in a different context, it gives some life to how states can raise this as a defense by virtue of the erga omnes. And then my final thought on this is that the stakes are really incredibly high. There's an estimated 2,463 investment treaties covering approximately 62% of fossil fuel assets owned by foreign companies. And you put that in the context of, for example, over 75% of foreign-owned coal plants require early retirement in order to meet climate mitigation targets. The scale of this is significant. There's some sense that there's 340 billion in ISDS claims that relate to just the question of what energy transition could look like. So these are profound questions, and I do think that what the ICJ has done in some particular findings on the erga omnes point really sets it up for the implications for other legal regimes, including ISDS.
Thank you so much, Catherine. So we're looking forward to see how this plays out in the future investment cases that certainly going to be many post the advisory opinion. But I want to now go back to Mamadou and something at which he hinted during his response, that this new generation of investment treaties, he said that there might be a sort of third generation of investment treaties that are post advisory opinion that react to the content of the advisory opinion. And we have this dichotomy of sort of old generation treaties that have only broad investment protection standards and wide access and unconditional access to investment arbitration versus the so-called new generation of investment treaties that try to circumscribe the standards, make them more detailed, etc. And in this new generation of treaties, they often expressly reserve the state's right to take necessary action for the protection of the environment, public security, health, etc. Yet these protections are generally either sort of affirmations recognizing the existing right to regulate, or they provide very limited guidance to tribunals, or are framed as an exception to otherwise applicable investment standards. I know you have an upcoming article in the making that analyzed how existing treaties incorporate climate change. Do you think so? I would like to ask you, what do you think? How do you think that the advisory opinion will push states to adopt these provisions, or even change altogether the approach to accommodate the findings, such as those that we've discussed up to now? You need to unmute still.
Yes, I think that we will need to really to look at this question from the past, and looking at the past in order to see whether the new advisory opinion may impact more climate change clauses in investment treaties. When you look at when did investment treaties start to include climate change clauses? Actually, it's just after the UN climate treaties were adopted. So after the Rio conference, you start seeing treaties mentioning climate change, but not a lot, not a lot. It's just the beginning. So from 1991 to 2010, I counted only 30 treaties that referred to climate change. The large majority of the clauses were a one-line clause, and it could be in the preamble or in passing somewhere in the treaties. And then from 2010 to February 2025, when I stopped my research, I found 79 treaties containing climate change clauses. And what was even more interesting was that since Paris, 61 treaties were concluded. So you can see that there is a correlation between major climate change treaties and state attitude towards including these clauses in their treaties. And since this advisory opinion is quite consequential, first by reaffirming clearly that states have obligation to protect and preserve the climate system, and that this trigger stringent due diligence obligation, but and even more, the fact that if they breach this obligation, they can be held responsible. I feel that this will again trigger a little bit more, may trigger more clauses, or it will rather strengthen the impetus in including climate change clauses in treaties. Now, I want to see how will that be? What are the type of clauses that we will see? Because what you notice is that actually current climate change treaties have treated the climate system as an environmental issue like all the others. And this is translated in the fact that what they do is that they mention the environment, including the climate system, or environmental measure, including climate measures. So they did not see that climate change was a challenge of a completely different nature, proportion, or scope. They just treated it as, let me say, business as usual, by just believing that the current treaties can accommodate climate change. And I'm wondering whether this is enough. Is it enough? is a climate a harm related to climate change exactly the same as polluting a river between a transboundary river or a forest? I just feel that the nature of the climate harm is just different uh, from that of our typical environmental issues. Now there is we can see in the latest trend in treaties in the field are what I call multilateral sustainable development treaties. These are treaties which govern climate change and the international economy. I will refer here just to two of these treaties: the 2024 Trade and Sustainability, the Agreement on Climate Change, Trade and Sustainability between Costa Rica, New Zealand, and Switzerland. So here, what you see is that we are not trying to incorporate climate change in an investment treaty. No, we are concluding an investment treaty focusing on climate change. Not investment, an international economic law treaty focusing on climate change, because the trade rules in these treaties are more numerous than the investment treaty. And also you have the Indo-Pacific Economic Framework for Prosperity Agreement relating to a clean economy. These two agreements reflect a different approach. We are not trying really to fit climate change in investment treaties, but we are perhaps seeing it as a systemic change in the field, and that could be the way forward. The other point that should be taken into account is that when you look at the practice, you have developing countries have not embraced climate change in their treaties. Specific climate change clauses do not appear in their treaties, and they appear only when they are negotiating investment clauses in a multilateral context. So with the EU or in the protocol on investment of the African Continental Free Trade Area. So it's just only in the multilateral context that these countries have been taking note of climate change. And the question is whether we should not consider bringing the issue of climate change and the economy in a multilateral context. I doubt that there is a strong consensus among states to do this through a treaty, but I feel that starting a discussion around a General Assembly resolution on climate change and the global economy can be the beginning of a conversation which will allow crystallizing the consensus about what are the obligations that can be accepted by state. I know that there are several treaties that started from non-binding General Assembly resolution, but I feel that this could be a way forward. Yeah.
Thank you so much, Mamadou. Now, I want to go back to the context of investment disputes and turn to Catherine. You mentioned and discussed the legal dynamics or the legal mechanics of erga omnes obligations and how they may play out. I would like to ask you that, given that the advisory opinion content will also affect the notion of legitimate expectations of investors, which is Mamadou mentioned that FET is the most common used standard in ISDS. How do you think that the arguments or the brought by advisory opinion about the erga omnes nature and about the fact that states incur responsibility if they fail to take all measures which were within their powers to prevent the significant harm, how will this affect the notion of legitimate expectation as one of the typical tools in the arsenal of claimant investors?
It's a great question, and I think that as Mamadou mentioned, the FET standard would be particularly relevant for claimants going into a context where the regulatory environment shifts on the basis of a state meeting climate obligations, which could include permits, concession contracts, and traditional energy, for example, being affected. And the FET being very commonly invoked, there's a particular subspecies of, as you say, legitimate expectations, which in and of itself is actually a controversial concept in the sense that it is really something that's arisen in the context of investment tribunal decisions. And many states, for example, have said that it's not a concept that is recognized as a minimum standard of protection of investors as a matter of international law. So in and of itself, it is something that's very much driven by the jurisprudence that's arisen in the investment context. And it's basically to the point that where investors are given specific promises, that gives rise to legitimate expectations that then become legally enforceable in the context of these bilateral investment treaties. So as you can imagine, that implicates and of where we are in the conversation about how climate change obligations intersect with the regulatory environment for respondent states. Now, going back to this, the FET standard does imply some regulatory stability. Investors are entitled to not have arbitrary, discriminatory, major shifts in the regulatory environment. But as is acknowledged by many tribunals to consider this, legitimate expectations is not a guarantee to regulatory freeze. Regulatory freeze is not what's necessary. And in fact, you can well imagine that regulatory powers need to develop for states in line with what priorities are, specific scientific developments, whatever it is, that regulatory powers must be flexible. So tribunals generally take one of two approaches in determining if a regulatory change, is a breach of the FET standard. The first is the degree of change test, which is what is the degree of change from an original baseline. And the second is the reasonableness or proportionality test, which asks on an objective basis whether regulation is reasonable. So on the first approach, where regulation, the degree of change, the delta, the idea is there a total, radical, fundamental, drastic, to use some of the language in investment arbitrations, change? And in the climate context, you can imagine that there may be some instances, given the urgency, given the stringent due diligence obligations involved, that a regulatory change might rise to that level. So it's clearly going to be implicated, and tribunals may be called upon to determining the effective reasonableness of that change from the regulatory baseline. And the second is the reasonableness test, again, in the climate context, where the scientific consensus surrounds the urgency, the necessary measures to avert not just harm, but catastrophic harm. That's going to come into play as to what is considered reasonably necessary for a state in terms of its regulation. So I think that international obligations, scientific consensus are very persuasive and relevant in establishing the reasonableness of the challenge measure. So going back to your question, this is all about what constitutes a reasonable defense for states in the climate context in light of the clarifications of the ICJ. And here, the ICJ opinion leaves little doubt that investors are on notice of the severity and exigency of the climate crisis, that they're on notice of states' rigorous and specific obligations to take legislative regulatory action to mitigate GHG emissions. And that will very highly likely influence on how tribunals interpret an investor's legitimate expectations, where a state comes forward and says these climate regulations are required by virtue of the scientific certainty about the exigency of the crisis and my state's other international obligations to mitigate GHG emissions. So then you start to see that there's a potentially very powerful impact on the fabric when it comes to legitimate expectations.
Thank you, Catherine. Now, back to Mamadou, I want to discuss a little bit that idea of shifting burden on private investors. You both mentioned that states found to have violated their international obligations regarding climate change may incur responsibility and liability, including requirement to pay reparations. And apart from the advisory opinion, other regional human rights courts highlighted or stressed the contribution of the private sector to climate change. Do you think that the advisory opinion will cause investment treaties to be rewritten or somehow changed in a way that shifts at least some of that burden onto private investors to change that classical structure of putting protection obligations on states and no obligation on investors?
Here I need to flag first one thing. You know that the word investment appears only twice in the advisory opinion. Only twice. So it's not the advisory opinion which focused on investment law. And actually the first one was a quotation, and the second one was to say that it was not going to deal with investment law. So it's not really the court was not really focusing on investment law as such. And all the insight that we are drawing from the opinion are really drawing from it. It's not direct state, they are not based on direct statement of the court on investment treaties. Actually, the Inter-American Court of Human Rights advisory opinion has more details on investment treaties and what they entail than the ICJ one. There are two things that the court said, and I feel that we have to take them into account when addressing this question of shifting the burdens. The first one is that the court held that actually the polluter pays principle was not one of the principle it will deal with. First, because it does not appear in the climate change treaties, even though it appears in some specific treaties, but it does not appear in the climate change treaties. And secondly, because also it does not impose obligation on member state, but rather on private companies. I think that this is a finding which already alter the perception of risk. If we had a finding which reaffirmed the polluter pays principle as a principle of international law, it would have already altered the allocation of risk from states to fossil fuel companies, but this is something that the court does not do. The second thing that the court does not do is that the court refused to pronounce itself on the law of international liability in respect of climate change. So this idea that states will be held responsible just based on the damage caused by greenhouse gas emissions, irrespective of the law of state responsibility, where you need to prove causality and other requirement and the breach of an international obligation. This also alters the allocation of risk, because if states were told that they will be held responsible or liable for all damage caused by the greenhouse gas emission, both this finding and the polluter pays principle would have pushed states to find ways to shift the burden to the most appropriate place. But still, the courts remain within the framework of state responsibility, and within the state framework of state responsibility, I see that the court has increased the perception of risk, and not just the perception, the risk relating to state engagement with the fossil fuel industry. How are states going to react to it? I believe that they will react to it more urgently if we have one state who is held responsible for the breach of its climate change obligation and for the relating damages. I also believe that domestic litigation is probably a more direct pathway to hold state responsible for failing the climate change obligations. Agenda and all these measures will probably prompt more reaction from states. And also one other factor which will may prompt state to adopt to rethink about the allocation of risk is the discussion that we are going to have at the UNGA with respect to the how we implement the court advisory opinion. All these movements, civil society, domestic courts, the ICJ, are all clarifying that engaging in greenhouse gas emissions through acts or omissions are just very risky. Unfortunately, so far, when you read treaties, investment treaties, and you try to see if they impose climate change obligation directly on investors, you don't find a lot. You find two type of clauses. You have clauses that specify that investors should expect climate change regulations. Okay, probably thinking about the fair and equitable treatment. But that's not the most constraining obligation. And then you have a clause that you find in the in the practice of the EU, where they say they have a clause directed to the parties and requiring them to encourage investors to contribute to the fight against climate change. So the obligations are not yet on the state, they are on the investors, they are on the state, but even their substantive content is that of encouraging investors to contribute to the fight against climate change through transfer of technology. So I think that does the court, to come to a short answer, does the court advisory opinion shift the allocation of risk? And not really. But it shifts the perspective, the perception of risk, and we hope that states will act upon that perception of risk, yeah, in their treaty practice.
Thank you so much, Mamadou. I want to move to the final question before we open for Q&A, and that follows from the question I just asked Mamadou regarding the burdens or shifts of the burdens, but now I want to zone in more specifically on the burden of proof and the dispute settlement context. And I believe that we already have actually a question from participants regarding the burden of proof. Catherine, ICJ held that to determine state responsibility in climate change context, parties would have to establish the causal link between the wrong flagged and harm caused in concreto evidence. It was just mentioned by Mamadou as well. Since such evidence is very difficult to ascertain in climate change context, especially when plurality of states and climate change consequences are concerned, how this might play out in ISDS cases in evidentiary matters.
So taking a step back in terms of what the court did in the AO itself, it's actually a very good example of the key differences between advisory jurisdiction and contentious jurisdiction, in the sense that the ICJ went, frankly, in my opinion, as far as it could and further than most believed in spelling out what causation might look like in the specific context of climate change. But the court implicitly recognized that it did not have a specific dispute before it and could not get into the weeds of specific fact patterns. And that's really what causation requires. So what the court did is it did a table setting, if you will, about how causation and the general principles of international law relevant to causation might apply in the climate context, but much really needs to be determined highly likely in a contentious case, because that's where specific facts will come to bear. But in terms of what the ICJ said, it is quite helpful and significant in this sense that the court said these general principles of international law, these regular, ordinary ways in which we think about causation and the triggering of state responsibility they do apply in the climate context. We don't have to go create a whole new set of norms, that these traditional norms do apply in the climate context. And in and of itself, that is actually a very helpful clarification. So when you think about what a showing a state must get into to demonstrate that its action was necessitated by the contribution of a specific project that's at issue in the ISDS dispute to GHG emissions on a global scale. That's the fact pattern in which this is highly likely to come up in the ISDS context. And it could be the ISDS context is perhaps one of the first examples of a contentious jurisdiction case that brings up the question of causation, which is very interesting. That instead of a state-to-state contentious case, you might actually have in the investment arbitration regime a context in which, as part of one of the defenses of a respondent state, the question of causation comes up in this very odd fashion, if you think about it, as a part of a respondent state's defense. But here, again, going back to what the court said in terms of basic principles, the existing standard for establishing causation is capable of being applied. That's the phrase used by the court, an important one, is capable of being applied in the context of climate change. And there the court was very much addressing the points made by several states in the submissions, both written and oral before the court, that in the context of a global good, a global common good, you cannot establish causation with any level of specificity or reliability such that state responsibility could be invoked. That's the underlying argument. And the court said no, that in fact harm could be seen as more tenuously established when it comes to global harm than in the case of local sources of pollution harm. But that does not mean that the identification of a causal link is impossible in the climate change context. And to use the words of the court, it merely means that the causal link must be established in each case through an in concreto assessment while taking into account the aforementioned elements outlined by the court. So this is where the legal principles in an advisory context, that's as far as that can take us. So what we're really looking at is the actual adjudication of contentious disputes will likely provide the necessary evolution and clarification of how traditional causation applies in the context of climate obligations. And I will note that the court acknowledged that this standard depends on the primary rule violated and the nature and the extent of the injury. So again, it'll be about potentially a respondent state's obligation in terms of when it says, I need to regulate in X fashion, which has Y effect on the investment, I'm excused from any breach in the treaty because it was necessary for me as the respondent state to take this action. Why was it necessary? That gets you into causation and causal link. And there, I think, again, the court acknowledged this. There's been a lot of discussion as to how attribution science relates to establishing the link. There's various organizations that have tried to amass what the scientific evidence of attribution would show as to how you can apportion individual state responsibility in terms of contribution to global emissions. It is not perfect. It is not at a level of scientific certainty that I would say the causal effects of anthropogenic GHG emissions are, but it is very much a point of international scientific focus as to how you think through attribution. And I think if you look at Judge Youssef's separate opinion, he specifically recognized the centrality of science to the question of attribution. And so that takes you to other potential applications of causation that are different than the norm in bilateral disputes. And that, for example, is the idea of joint and several liability on the international plane. It's a bit controversial. Judge Sima, I think in his separate opinion in oil platforms, made a very good case that joint and several liability is a general principle of international law. But again, that's somewhat controversial. And what that basically means is that, and it's used in domestically, the question is there a concept in international law? But it allows multiple wrongdoers contributing to an indivisible injury to each be held liable for the full extent of the injury, which if you think about in the climate context, it boggles the mind as to what it means to hold one state or a group of state liable for the entirety of the damage to the climate system. So I'm not suggesting that it is a one-to-one application of these general principles, but again, you could imagine a context in ISDS in which for the first time you will have a contentious case that really looks hard at these traditional principles and how that translates. The other theory that I've heard invoked is one called market share liability that's used in, for example, the United States in toxic tort cases, where liability is apportioned based on the individual tortfeasor's market share. You could potentially think about liability apportioned based on cumulative GHG emissions. So there's all of these concepts that are in play, so to speak, but what happens on the international plane, I think very much remains to be seen.
Thank you so much, Catherine and Mamadou. I think this was very, very interesting discussion. I enjoyed it very much. And I think that it also, a testament to that is that we have plenty of questions, both at the Q&A and on the chat. So I think that we can now open the remaining 15 minutes approximately to have to answer some of these questions that we can see. And I think that Catherine in the last answer mentioned the limits of advisory jurisdiction as compared to contentious cases. And I think that actually the first two questions we had on Q&A were about the binding or non-binding nature of advisory opinion. Could any of you clarify the nature, the legal nature of advisory jurisdiction and the opinions for non-international law specialists in our audience?
I can, Mamadou, would you like to start, or I can start?
Okay,
however.
please go. Yeah.
Just generally speaking, we got this question a lot, as you can imagine. It's what is the use when it's non-binding? And I think it actually, that question itself, it's an apples and oranges. So what the advisory opinion jurisdiction, in and of itself, it's non-binding because there is no actual contentious dispute before the court. The court is not resolving a specific dispute. What the court is doing, however, is clarifying what international law requires. So to suggest that there's no binding aspects to it really misreads the exercise before the court. So what the court has done as the highest judicial organ of the United Nations system is set out what is an authoritative statement of international law, not from July going forward, but what international law has required vis-a-vis the climate protection and the climate change system. And so embedded in that are observations, and Jennifer did a tremendous job going through some of the elements of those obligations that are binding on states, whether by virtue as a customary norm of international law or by virtue of the climate change treaties and being states parties to those, or to UNCLOS and to the various regimes that the court has addressed. So to walk away from this exercise with a sense that the advisory jurisdiction is not binding in and of itself, I think misses the point of what this treatment of international law clarifies as to what constitutes binding obligations on states. So all of this will no doubt come into, I think, sharper focus in, if there is, a contentious case on the international plane. That will take, I think, some of these principles and really hash out in the context of a state-to-state contentious dispute. But of course, today we've been talking about how it could manifest in other legal regimes like the investment arbitration system. So I hope that explains, but I think it is a very significant opinion that has lots of implications.
Jennifer, you wanted to add something?
Yeah, because the specific word compliance was mentioned in the question in relation to the NDCs. I think one thing that surprises a lot of people is that there is a specific compliance committee for the Paris Agreement, but it has this non-punitive facilitative approach, right? Something that we've heard a lot in the oral hearing, actually. And so even though the court specified obligations in relation to NDCs, this specific compliance committee is not going to carry out the duty of assessing the NDCs in terms of substance. They do already look at the sort of timing requirement. So have you submitted the NDCs, but not the substance? This is something that will be debated elsewhere. For example, the advisory opinion gives citizens much more tools in hand to pressure their own governments vis-a-vis their expectations in NDCs. And also there, because we've talked a lot about the fossil fuels, I want to link to some of the sort of voluntary self-commitments that a lot of emitting countries have gone, for example, in alliances on removing fossil fuel subsidies, for example. And so these are also tools that can be referenced in terms of highlighting the, at least on paper, intent of countries to transition away from fossil fuels, to also address the consumption side, right? And so I think one of the key things here is that we've seen so many countries come forward to the court, and we'll see the advisory opinion reflected at the level of the UNGA. So no country can say anymore, I wasn't aware, I have a different interpretation. The risks are clarified, and so they can be held accountable way better than that has been the case before.
Amadou.
Yes,
Thank you,
just
Jennifer.
one tiny comment here. I fully agree with what Catherine just said. There is one point which is often, which I wanted to stress, is that, okay, even if formally the advisory opinion is not binding, substantively the norms that the court determines, the rules are binding. But even more, is it binding towards the General Assembly and the United Nations? Because this is a determination of the principal judicial organ of the United Nations. So the United Nations as a whole and as the center of contemporary international relations is bound to follow the legal advice that has been provided by its principal judicial organ. And this can translate into a variety of fields and actions of the UN. So I think that really, but it's a common question, but I think that we will see the advisory opinion producing much, much more effects and than we can even think of. Yeah.
Thank you. I think that unless there's a specific questions that our panelists picked from the Q&As they would like to address, I think that I will just arbitrarily pick some of the questions that are there and read them out loud. So I think that there's one question which relates to climate and to policy space and adaptation and mitigation, and it's from Sophia Danke. And she asks, to what extent does the ICJ climate advisory opinion recalibrate investment law towards protecting adaptation policy space, local value addition, community benefits, resilience planning, etc., rather than primarily reinforcing mitigation obligations? More specifically, I'm thinking about the energy transition and how investment protection chapters limit policy space in mineral-rich economies, preventing economic diversification and fair value capture domestically, essentially hindering adaptation efforts.
I can take a first stab. It's a terrific question, Sophia, and I think it goes to something that maybe has been implicit in this conversation, but I'll make it explicit, which is these are going to be very difficult balancing exercises. It's not as if a respondent state vis-a-vis a particular investment, having undertaken a regulatory change, can say, it's my get out of jail free card. Here's the advisory opinion and climate obligations, and it's a full defense. We're going to have to grapple with what a just transition looks like, which is far more complicated than investors are always in the wrong or states are always in the wrong. And so we're going to have to grapple with the fact that the transition from traditional energy cannot be accomplished without some significant costs, especially to the global south in terms of staying above the poverty level, unless you take a very balanced approach to that, how that happens, where we basically protect the rights of individuals to cheap energy that keeps many countries above the poverty line, as well as protecting the climate system and the environment from these existential crises. So I think when it comes to this question, Sophia, in the adaptation sphere, that's just one example of where that balancing really needs to be hit in a nuanced way. And something that pains me to a great degree is how polarized this conversation about climate solution, effective climate action has become. Because to me, without the interrelationship, the necessity of balancing both traditional energy and just transition points, we're not going to get to a global solution where everyone comes along with it. So I think that that's going to be a really important balancing. It could very well be, for example, that in an investor context, where a state decides that because of its climate obligations, because of the exigency of the crisis, it needs to effectively expropriate an investment in the name of that. It could be that what we're experiencing now is something called lawful expropriation, where you have a legitimate regulatory action. But guess what? Because an investor has rights, the balancing is that the investor is given adequate fair compensation, because that investor as an individual shouldn't bear the cost of a global adherence to climate protection. So I just think that in the adaptation space, to your question, these very important balancing needs to be undertaken, which is why in the contentious context, you'll actually have particular fact patterns that allow us to do this versus on an abstract level, which I don't think we can get very far about what the trade-offs look like. So to the very short answer to your question, I do think that investment law will need to be recalibrated in a way that protects the regulatory space on mitigation, on adaptation. But what that recalibration looks like is not going to be, I think, entirely clear and needs to be dependent on the particular facts of an investment.
Thank you, Catherine. Jennifer.
Yeah, I want to use this opportunity to add a point that we haven't really touched upon here, but that was addressed in the advisory opinion, is looking at specific vulnerable populations. And here in the context of the energy transition, especially looking at mining for resources that will be needed to ramp up renewable energy, it's important to emphasize indigenous people's distinct rights. We have a lot of those resources that are found on indigenous people's territories. And so they have been flagging that in the context of the climate negotiations, but also in the biodiversity negotiations on addressing this challenge, how to reconcile the need to speed up the transition while at the same time guaranteeing their rights, especially for free, prior, and informed consent, and keeping that balance in mind. I think that's one of the key issues that is being discussed in the negotiations on just transition, right? Trying to see how to get everybody on board, including the workers in the oil and gas sector, for example. And that is an expectation that countries are supposed to address in their NDCs. Few have done. We see very timid examples in that regard. But it really ties into a lot of the things that were highlighted in the advisory opinion on human rights obligation in general, including related to the right to a clean environment. So I think there's a lot of hooks that could be addressed in relation to that question that was just posed.
You are on mute, Joseph.
Thank you. Thank you so much, Jennifer. So I think that we have time to answer one last question. I know that there was one question which referred to the quote you made, Catherine, to a separate opinion regarding the impact of community interests on bilateral disputes, whether that quote can be either copied to chat or referenced. I think that would be really useful for all participants, myself included. But I think that the last question, I think I will pick one of the questions asked by Christian Haberli. He asked two questions about the burden of proof in the different contexts. I think that we covered that. But the third question was about the development under Paris, seeing how busy the least previous GHG emitters are trying to catch up by building up their energy and mining production, can the ICJ opinion steer their legitimate development needs away from fossil fuels project? And finally, he also wanted to ask specifically about the emissions from agri-food industry that we, of course, discuss very often, the fossil fuels, but what about the agriculture and food systems emissions? Anyone wants to tackle that question?
No, I think I will pick that one first. I think that one thing that the court did, which was welcome in the advisory opinion, was to actually reaffirm the principle of common and but differentiated responsibility. So it leaves a certain space for these developing countries and also the right to a sustainable development. So the principle of sustainable development. So these two principles, as they operate, may give some space to these developing countries to be able to pursue their development without being energy poor, because energy poor for these countries is also as bad as the consequences that will arise from climate change. But I also feel that there is a space for these countries to contribute to the fight against climate change by just not repeating the same mistakes that we did post-industrialization. They don't need to develop carbon-intensive economies such as those that we have created in the US, in Europe, and in other places. And they can think about more green solution for transportation, for energy. And that is an entire space where they can be leading the transition towards a green economy. So my perspective is that, okay, they have this common but differentiated responsibility, but it's also imposes on them some creativity not to necessarily follow the carbon intensive economy style that the others have followed before. Yeah. Thanks.
The only thing I would add, I completely agree with Mamadou's point, is that there were some delegations that argued that CBDR, common but differentiated responsibilities, was actually defense in having to implement climate mitigation and adaptation measures. So India, for example. And the court, interestingly, didn't say this explicitly, but did not adopt CBDR as a potential justification or defense. So effectively rejecting the idea that these countries could, frankly, as Mamadou say, make all the mistakes that the industrialized nations did in terms of the energy transition has already taken place. So that it has to be more nuanced, it has to be more balanced. So that implicitly, I think, comes out in the court's opinion based on what certain countries argued and was ultimately rejected by the court.
Thank you so much. I think that this is a great. On this note, I think it's great that we thank our panelists first and foremost, Catherine, Jennifer, and Mamadou for spending time with us discussing the implications of the advisory opinion. I want to thank my colleague Elena and Susie and the interpreters who interpreted into French and Spanish this webinar, and Yelena and others who, Scott, and who assisted at the back end for making this webinar a reality. And last but certainly not least, I want to thank to all the participants that logged in today to